Hello, everybody. This is Ask Carter Law back again with our very special series on intellectual property with the Carter Law Group. Today, we'll be discussing name, image, and likeness and what that has to do with the rage over NFTs. So quickly as a recap, if you haven't watched previous videos on our discussions on name, image, and likeness. Name, image, and likeness are rooted in the law of the right of publicity, meaning third parties are not allowed to publicly monetize and use your name without your permission and or compensating you. So what does name, image, and likeness have to do with the rage over NFTs? Well, simply put, third parties are selling digital assets and content, aka NFTs, using the likeness of third parties without permission and monetizing it. Let's rewind for a bit for those that are not as tech savvy. What are NFTs? NFTs are non-fungible tokens. Again, what are NFTs? Essentially, they're non-fungible in the sense that they cannot be replicated. They can't be reproduced. They can't be exchanged. Like if I give you $1, you can give me 4 quarters. They're equivalent. However, in the case of NFTs, each digital asset is unique. What are some of the examples of some of these unique digital assets? Memes, tweets, pieces of digital artwork, videos, anything that could be digitized and sold and essentially be one-of-a-kind pieces of assets, something that could never be duplicated or replaced. Now, where exactly are these digital assets being sold? They're being sold on various crypto databases such as OpenSea, Rarible, which are probably the top 2. But then you have other places like CryptoKitties, other marketplaces that are coming up to compete with these marketplaces. All of these marketplaces are the digital background for the cryptocurrency that you have, such as Bitcoin. So now let's discuss some examples of popular NFTs that have sold. For example, you have Jack Dorsey, the founder of Twitter. His original tweet, so his very first tweet, sold for $2.9 million. We also have LeBron James. There was a slam dunk he did on video that recently sold for $200,000. And let's not forget our younger generation who are definitely tapping into the marketplace with their music. Young artists such as Soulja Boy have created unique songs that have never been sold. And again, use the open marketplaces such as Rarible and OpenSea to sell these one-of-a-kind songs on the NFT marketplace for thousands and thousands of dollars. So this is definitely a market you want to learn and understand and get in on. So now let's discuss when NFTs go wrong. The latest scandal over NFTs are with a group of persons that are calling themselves the Floydies, representing a group of people that like to digitize the likeness of George Floyd. And I think we all know who George Floyd is. He was killed by a police officer, and that officer, Derek Chauvin, was found guilty of murder. The likeness of George Floyd is being digitized into various forms of digital artwork and being sold currently on the OpenSea market by this group calling themselves the Floydies. It has sparked rage. It has sparked conversations about capitalism. It's obviously sparked conversations with the Carter Law Group about intellectual property and if these people actually have the right to do this without the permissions of the family of George Floyd. Because he's such a public person, a lot of his images have now been put in the public domain, and people are using it in various ways, and in this case as NFTs to make money off of it. Now, this begs the question, well, if it's in the public domain, isn't there a law or rule called fair use that, you can use it to a certain extent without infringing upon that person's right? And in this case, the family's right, because the person is no longer here. So their intellectual property right would pass to their families. Are they really infringing? Well, fair use really is only for educational purposes, news purposes. If you're only using a small portion, when you are moving into the NFT marketplace where the complete image of that person is being used and it's being completely monetized, I don't think there's a strong case of fair use. So whether you're an individual that's still alive that is a public figure, or you're famous, or you're considered a celebrity, and you notice that your likeness is being digitized and sold as an NFT, or if you have a loved one where again, you've inherited the intellectual property right of a loved one that was a very highly visible person. It's important to enforce your rights over third parties using it and monetizing it without your permission. The best place to start in enforcing your rights or the rights of your loved ones is to hire a lawyer, and then that lawyer will check the jurisdiction and the law of the state where you or your loved one lived, just to confirm that there is a right of publicity even in death. And if there is, in fact, a law on the books, because again, most states do have this law, then they can go about sending out cease and desist letters and really enforcing persons not using the likeness and monetizing it without your permission. Thank you for joining the Carter Law Group's special series on intellectual property. Until next time, check out all our videos on intellectual property and your latest favorite celebrity legal hot topics on our website, www.AskCarterLaw.com, and also on all our social media handles at AskCarterLaw. Until next time, take care.